Hi everyone, my name is Melissa Willette from Santa Clara County. Welcome to the grievance process part of the Know Your Rights online training. Let's get started. What is a grievance? So contracts usually contain a definition of what a grievance is and what matters can be considered under the grievance process. Check your contract to see what types of violations are considered grievances where you work. Generally, it is a dispute over the application or interpretation of the provisions or rights in the contract. Remember, contracts mostly benefit workers, not management. If there is no contract, management could do whatever they wanted. So sometimes, management ignores the contract or tries to operate outside of it. Other times, they simply don't realize they're violating it. Contracts are long and hard to memorize. Most of the time, grievances result because workers and management disagree on what the contract language means or what is intended to mean. The grievance process provides a way to resolve these types of dispute. It does not cover disputes over issues outside the contract terms. For example, discrimination, harassment, and other federal violations fall outside of collective bargaining agreements and therefore are not resolved through the grievance process. There are other processes in place to report these types of issues. The grievance process also doesn't apply to non-contractual issues, such as personality conflicts or hiring decisions. Some contracts even spell out issues that are specifically excluded from the grievance process. Why do unions file grievances? To protect and enforce the contract. Unions do have to police the contract. They also have to educate the boss, labor relations, and management lawyers. They also want to file grievances to resolve issues early. So before we go into more details on how to investigate a grievance, let's talk about the Contract Enforcement Department, or what I'll refer to today as CED. The Contract Enforcement Department, CED, is a department unique to SEIU Local 521, staffed with personnel who are experts in grievances and disciplinary issues above the Skelly hearing level. This is who you and your steward will contact if there has been a contract violation. The Enforcement Department is staffed by a director, contract enforcement specialists, or CES, contract enforcement analysts, or CEAs, contract enforcement specialist assistants, CESAs, and administrative assistants. The director is in charge of the Contract Enforcement Department throughout the entire local, ranging from Region 1 to Region 5. The San Jose CED staff covers Region 1, which is San Mateo and Santa Clara counties. The Santa Cruz and Salinas offices have staff for employees in Region 2, Monterey, Santa Cruz, and San Benito counties. The Fresno office has CED staff for 2 regions, Region 3, which is Alpine, Mariposa, Merced, Mono, Stanislaus, Tuolumne counties, and Region 4, which is Madera and Fresno counties. And the Bakersfield and Visalia CED office staff covers the following counties in Region 5: Inyo, Kern, Kings, and Tulare. The CED process. When a member has a concern with something at the worksite or a question on the union contract, they will contact their worksite steward. If there's a steward available, the steward will work with union staff and CED to resolve the issue. If a steward's not available, the worker can contact CED directly. CED will get them a steward to work with them and the union staff with CED to resolve the issue. The Contract Enforcement Specialist Assistant is going to be your first point of contact when you call CED and is responsible for handling incoming telephone calls, opening cases, correspondence, case tracking, updating member contact information, assisting the CES in calling back members, discussing matters with stewards, drafting grievances, answering steward calls about the status of cases, and so much more. The contract enforcement specialist is responsible for formal grievances at all levels beyond the informal discussion and review, from the first formal step through arbitration. The CES is responsible for meeting timelines on all related aspects of the formal grievance process. They work with stewards to resolve grievances through formal grievance meetings, administrative hearings, settlement discussions, and everything else. So let's talk more about how we investigate a grievance. Investigating a grievance. When a worker comes to you to report a contract violation, there is some information you need to collect before contacting CED. First, find the right time and place to talk to the worker. You're going to want to find someplace private, but don't delay. There are time limits you have to be cautious of. Have a copy of the contract with you. Ask the 5 W's, and fill out the worker and steward intake form. The 5 W's. Who is involved in the grievance? Is there only one person affected, or is this a group grievance? What is the grievance story? Listen to the whole story objectively. Don't make any assumptions. When did the contract violation occur? Where did the violation take place? Why is this a grievance? You want to ask yourself specifically what section of the contract has been violated. And lastly, how can the violation be remedied or resolved? The worker and steward intake form. Use this form when interviewing the grievant. This helps you gather information CED will ask you when you call them. Have the worker read the statement and sign the document. Of course, the signature is not mandatory, but helps you get buy-in from the worker throughout the process. Contact CED by phone before faxing or emailing the worker and steward intake form. CED staff will ask you for the information you have collected on the form in order to open a new case. The CISO will ask if you have had an informal meeting with the immediate supervisor yet. So this is typically the first action required in a grievance process. If you are comfortable, it is okay to do this prior to contacting CED. If you prefer to call CED first, they'll talk you through how to do this. And of course, pay extremely close attention to the time limits listed in the contract. Time limits. Contract grievance procedures contain time limits, and time limits are short for a good reason, but can be used against us. What happens if we miss a time limit? The employer could win on a technicality. And what happens if the boss misses a timeline? We may be able to appeal to the next level automatically, but we must make sure timelines are met. The importance of a good investigation. Investigate at the first step as though the grievance is a potential arbitration case. A good investigation will expedite any settlement, and a good investigation helps to build your confidence as well as the confidence of the members in you. Investigating a grievance checklist. The following checklist will assist you in doing a good grievance investigation. Interview the grievant. Keep written records of all interviews. Determine if the problem affects others in the workplace. Determine if there is a contract violation and the remedy desired. Seek advice if needed from a chief steward or union staff. Anticipate management's arguments and prepare for them. Pay attention to time limits of your grievance procedure. Informal meetings and time limits. It's important that you attempt to settle the dispute at the lowest possible level, or informally, with the worker's immediate supervisor. Informal meetings must take place within a specified time of the events on which the grievance is based, or after the workers or the union's first knowledge of those events. The supervisor shall respond orally or in writing within a specified time of the informal meeting. Informal meetings and time limits. I can't tell you exactly what the time limits are in your contract because all contracts are different. Be sure you become familiar with these deadlines. And remember, time limits may be extended or waived at any level only by written agreement of both parties involved at that level. Formal grievances and time limits. If the grievant remains dissatisfied following the informal discussion and review, the grievant may submit a written grievance to the employer within a specified time. Formal grievances are submitted by CED. The employer has a specified time to respond in writing to the grievant and the union of their decision. Depending on your contract, there may be multiple steps of the formal grievance process where the grievance can be appealed to managers or officials higher up in the organization. Again, refer to your contract for the rules and time limits of each step of the formal grievance process. A final decision. If a contract disputes cannot be resolved or settled by the parties through the formal grievance process, contracts contain provisions for a final appeal or arbitration process. Arbitration is a semi-formal hearing before a third-party neutral arbitrator and is usually final and binding. There are various other types of appeal board or panel hearings that may make the final ruling on whether or not the grievance will be granted. Refer to your contract for the final appeal step of the grievance process. Release time. Union representatives employed and recognized by the employer may assist workers in resolving grievances at the lowest possible administrative level. Most contracts allow for release time, so check your contract. Release time means that union representatives and grievance may prepare and present grievances during normal work time. The employer should grant reasonable periods of release time, and the union shall make a good faith effort to request release time at least 24 hours in advance, if possible, or as much in advance as reasonably possible or as directed by the contract. CED is here to help. If you need any assistance investigating a grievance, contact your local union office and ask to speak to the Contract Enforcement Department. That's all the basics of the grievance process. Make sure to take the quiz below this video. After you take the quiz, you will be able to download a handout. Thanks so much for watching the video. Bye!